You worked hard your whole life, you saved your money, you were disciplined with your spending, you invested well, and now you have a will that is going to leave money and property to your children and other loved ones. That's the American dream. You're giving the next generation a leg up. And that's a great feeling, right? But there's one mistake you might be making, and I want you to be aware of it. My name is Patrick Cawley, and I'm an elder law attorney with Keystone Elder Law. The difference between an elder law attorney and someone else who might do estate planning as part of their legal practice is that elder law attorneys know how the various types of estate planning might affect public benefits. So keep in mind the following situation. Husband and wife have a will. They have what we like to call an I love you will, where it says, I leave everything to my adoring spouse, and if my adoring spouse passes away before I do, then I leave everything to my children. And that's a very common arrangement. But what happens if, as they get older, husband has to go into long-term care? He has dementia, he has Parkinson's, he has some physical disability that requires extensive nursing treatment around the clock. That's also very common. Well, Medicaid will pay for the long-term care for that husband. And in order to get him on Medicaid, we need to adjust his assets so they come way down, probably because we're transferring a lot of the assets to the wife. Now that we've transferred all the assets to the wife, we've gotten assets out of the name of the husband, what happens if the wife passes away? Her will says, I leave everything to my husband. And now all those assets come back over, and the husband will be way over the limit for what he's allowed to have and still qualify for Medicaid. So now all of the hard-earned savings are going to get spent on a nursing home rather than going to the children in this case. So that's what you want to avoid. The same situation comes up when someone has a child with special needs. Maybe that child's going to rely for decades after the parents are gone on public benefits provided through the Social Security Administration. That's becoming more and more common. We read about those cases all the time, the rise of autism as a diagnosis and so forth. So you don't leave money outright to a person, whether it's an older person on long-term care benefits or a person of any age on benefits for someone with a disability. Because if you give them money outright, their disability benefits go away. And that's a tragic outcome. So what you do is you build it into a trust. You put a trust in your will that says, look, don't give money outright to somebody who is on any sort of public benefits. Instead, put it in this trust. The trust money can still be used to enhance that person's quality of life, pay for all kinds of things that will make their life better while not disrupting their Medicaid or their Social Security benefits. And the truth is, you just don't know if your spouse is going to need long-term care. There's about a 70% chance that he or she will. And you don't know if any of your children or grandchildren who might be included in your will need disability benefits. They might be healthy today, but we are all one car accident away from a debilitating injury that could result in us needing long-term care benefits and disability benefits. So don't make the mistake of just leaving money outright with no asset protection in your will. The asset protection comes with built-in trusts inside your will that are there just in case there's somebody receiving public benefits. If you have any questions about this, if you want to know if your will it looks like it should, just let me know. Shoot me an email, info@keystoneelderlaw.com. That's info@keystoneelderlaw.com, and we'll make sure you're on the right path.